before you today is a proposed amendment to the to Chapter 2290 of the Santa Barbara Municipal Code, having to do with the Conejo Slide area, specifically what's been called for about 28 years Slide Mass C. And I've, well, by way of background, in the winter of 1983-84, which was a very wet winter, shortly after that, the city started seeing that there was quite a bit of earth movement up in the Conejo Road area, again here near the area of Eland Place, Conejo Road, above Stanwood. And in fact, I think on January 1st of 1984, a home essentially broke in half and was completely uninhabitable, and several homes slid off their foundation. And about a year after that, it took the city about a year to study the problem with geologists and with engineers, particularly in terms of engineering proper utilities and proper access up there. But about a year after that, the city first enacted a building moratorium ordinance in that area, which prohibited new construction. It allowed the existing construction to remain, but it prohibited all new construction. And it, based on a geologist report at the time, came up with these slide mass areas, which were essentially down to one problematic slide mass area, and that's slide mass C. That ordinance from 1985 was for a 5-year period, and in roughly 1991 it was extended again by the City Council because we were beginning to understand that the geology was such that it was not going to be fixable. This slide mass is an ancient slide area. In other words, it goes back perhaps hundreds of thousands of years, if not more. It's not actually an uncommon thing in that area of the city. And the nature of it was that it was so deep, it really was beyond anyone's ability to afford to fix it, even if it were fixable, and that wasn't clear. In other words, you could excavate a lot of soil, but having done that, the engineers and geologists couldn't tell you how you could put it back together in such a way that would fix the situation. At the same time, this is not like I think some cities have seen an extreme, say La Conchita or in Laguna Beach and other areas of Malibu, where there is an extreme slope, and such that the slope would fail and homes would come crashing down, say, down a hill or down to a highway or something like that. That's just not the nature of the topography up there. The homes do eventually, some homes have been destroyed. In fact, I believe there's been 8 homes destroyed in the last 28 years in this area, but it's more of a gradual process. It's not, like I say, catastrophic failure in the middle of the night where it comes crashing down. So then 4 years ago, 3.5 years ago now, we experienced the T fire, and it burned through this area, and it burned quite a few homes in this area, including homes within Slide Mass C. And the question came up when the city prohibited new construction, was it going to interpret that in such a way that it applied to someone who lost their home as a result of a fire? And this question came up hypothetically, if you will, in 2001, when one of the homeowners in the area who was concerned about their ability to market their home retained an attorney and came to the City Council and asked the City Council if their interpretation was that new construction included construction after a fire. And the Council's answer at that point in time was yes. I think the rationale at that point in time was eventually we would like to see, we as a city would like to see, and it may take quite a few years, no homes in that area, in the area of Slide Mass C, because even though there isn't danger of a catastrophic failure of a home, It's just the utilities become disconnected. The homes do go off their foundation, come off their foundation, and some homes have been destroyed. We have been in litigation since 2009 over the city's interpretation, the city's application of this ordinance to the T-Fire homes, to the property owners who lost their homes in the T-Fire. And recently, we received a Superior Court decision which indicated that the city did not have, in the judge's opinion, sufficient justification to prohibit new construction after a fire. And the judge did decide that the fire triggered a new statute of limitations, and as a result, the people who sued the city after the T-Fire over this ordinance were within their rights in filing such a suit. It was, in other words, it was a timely suit. And then, as I say, he recently decided that there is insufficient public policy justification, if you will, insufficient evidence of a dangerous condition such that the city can prohibit new construction in the event of a fire or similar casualty. So the ordinance draft that you have before you today seeks to address what the judge indicated we had the ability to do. And it would allow those property owners who lost their homes in the T-Fire or who might lose their home hereafter within Slide Mass C to rebuild their homes. So in the case of the T-Fire, there were 3 properties in particular, 17 Eland Place, 474 Conejo, and 478 Conejo Road, who the homes were burned down in the T-Fire, completely destroyed in the T-Fire. And I know this map is a bit hard to read because it's pretty detailed. It's a topographic map, but I have indicated in yellow highlighter the homes at 17 Eland Place, 474, and 478 Conejo Road. Now, the home below that, 486, is interesting, and it actually was a significant factor in the judge's decision because that home was not burned in the T-Fire, and that home does not appear to have any sort of habitability issues with earth movement. It is apparent that the foundation has been repaired, but other than a foundation repair, that home is perfectly habitable and has been for the last 28 years. And so as a result, that the habitability of that home, the fact that that home has not been affected by Slide Mass C and is essentially in the middle of Slide Mass C, I think was a major factor in the judge deciding that the city did not have sufficient evidence to prohibit new construction. There are some other homes in the larger area of Slide Mass C, and that's this outline blob is Slide Mass C, more down towards Sycamore Creek, and I believe they're all these would be Stanwood addresses: 1815 Stanwood, 1809 Stanwood, and 1761 Stanwood. I do not believe, maybe Mr. Estrella knows for certain, pretty sure 815 was not burned in the T-Fire. 809 was not burned in the T-Fire. 809 is actually what we always understood to be an outbuilding or a shack, but was a few years ago discovered to be a historic structure and was a designated historic structure. And then 1761 is a home, and none of those were lost in the T-Fire, but the import, excuse me, the import of the judge's ruling would be that should they be destroyed by fire in the future, they could then sue the city again and claim a right to rebuild. So it's my recommendation that we include those properties as well as 486, which, as I say, was not destroyed in the T-Fire, in this ordinance. I have a larger map, if need be, but that map is color-coded to show those properties which are actually now owned by a nonprofit entity. And this has to do with in the late 1990s, specifically 1998, the state and the federal government had some FEMA money available for disaster areas and for specifically for areas subject to earth movement, to landslides. And at the prompting of the homeowners in this area, we assisted them in forming a nonprofit corporation and in applying for this FEMA grant. And I don't have it indicated on this map, but I think 5 or 6 of these properties sold their homes to this nonprofit corporation. The homes have been removed. In some cases, they were damaged in the first place. The homes have been removed, and if you look at the bigger picture now, I think almost 30 years after the city enacted this ordinance, there are actually very few homes, these homes, left in Slide Mass C. And it may be, as the geologists some geologists have recently said, that these parcels can be built on. And that was, as I say, the basis of the judge's decision. This ordinance is not changing anything in the Uniform Building Code or the uniform codes or taking away any existing discretion that the city's building official has. And, Santa Barbara, like I think probably all cities, requires a new home, for example, to be supported by a soils report. If you've got a vacant parcel and you intend to apply for a building permit from the city, one of the things you've got to submit is a soils report, which really looks at the question of how suitable say, a proposed home site is for construction, what recommendations the soil experts, and typically these are geologists, and the soils report is based on borings, what recommendations are being made with respect to the foundation. And then, of course, those are just recommendations, but under state law and, again, the Uniform Code, you have to have a licensed professional design your home, including your foundation. And it's not uncommon in Santa Barbara to have a structural engineer design your foundation in conjunction with an architect. So I think the point here is that the city building official will still be looking for all of that. We'll still be looking for whether it's the architect or a structural engineer or some other licensed professional that under state law can design a home and design a home foundation, to say your foundation's got to match up with this soil report, and it's got to demonstrate clearly that this foundation is not going anywhere for a long time. That's all still going to be true in Slide Mass C if this ordinance is adopted, if these homes are allowed to rebuild. And I guess my final point would be, because of all of that, I don't think the city is suggesting, or it would be honest to say that it will be easy to rebuild these homes. But I think the homeowners, the property owners, recognize that. Even their geologists had some quite specific recommendations for the type of foundation that needed to be built. And it was a pretty substantial foundation, and it was designed in such a way that it would, according to their geologists, could move in some ways. They might have to go out and re-level the walls, and they might have to go out and reconnect the utilities. But according to their geologist, and as I say, the judge agreed, there was nothing particularly unsafe about the approach. So with that, I'd be happy to answer any questions you might have about the ordinance or the background of this.
Okay, let me just do this one thing. Is there anyone here who has public comment on this item? Seeing none, we'll close the public hearing. And Mr. Hotchkiss.
Thank you, sir. There are other homes in the slide mass that are not yellowed out, correct? Looks to me like 454, 493, 8, whatever. Are they covered by this new ordinance? Would they be covered?
Mr. Wiley?
If the only ones that would be covered, and I believe those yellow, the highlighting, are the only ones left, are the homes which were, let's see how to say this. If a home existed on the date of the T-fire, that parcel could be rebuilt on. But most of these, and I could show you on this map, most of the parcels in slide mass C did not exist on the date of the T-fire. Like I say, 8 of them were destroyed by earth movement before the T-fire. 5 of them sold out to this nonprofit.
Okay, so anything that's in the slide zone C would be covered if it either was burned down in the T-fire or existed now, and we don't think
That's correct.
Okay.
Conversely, it's hard to see on here. There's a hairpin turn on Conejo Road.
Right.
And it's just above what's called Conejo Lane. That parcel in the hairpin turn was a private parcel owned by Jim Del Monte that had a home which broke in half on January 1st, 1984. That could not be rebuilt because it was destroyed. It was removed in 1985. I'm sorry, 1984. That's not benefiting from this ordinance.
Second question, if there are utility problems in this area, who's responsible for maintaining those or repairing them?
That's a good question. Well, the city utilities, water and sewer, is the city responsibility in terms of the mains in the street. Laterals, whether it's gas, electric, water, sewer, are the responsibility of the property owner. And most of the problems in this area have been with respect to laterals. But it is a tough problem for the city, particularly for city public works, whether it's here or areas where there's other parts of the city water service area, for example, where we have to provide water service and we have earth movement. It's sort of the cost of doing business. If you're a water purveyor, you've got to go in there and fix it, sometimes fairly often because of earth movement that's not caused by the city water service.
Would it make sense if these went on septic instead of sewer?
Oh, I'm sorry. There is a companion ordinance, again, from 1985 that prohibits septic in this area. It has, so I don't believe, I don't know about any, we haven't allowed septic up there for 28 years. Right, and the city public works they're taking some steps to reroute sewer mains up there to provide better sewer service and sewer service in a way that should not break in the event of an earth movement.
Thank you.
Mr. Rouse?
Mr. Chair. Mr. White, go back to the part about the nonprofit that bought some of these properties. What's the nature of that organization and intent, and are they a named party or?
No, they weren't. There's been no litigation. It's just this state federal grant process required someone to take title to these parcels that were being sold and basically covenanted to be open space, to never have any improvements on them. Sometimes you can get some nonprofit organizations, some conservation, environmental organizations to take the Trust for Public Lands, or in Santa Barbara, it's called Santa Barbara Trust for, I can't think of the exact term. They own Arroyo Hondo, I believe, out in Gaviota.
Land Trust.
Santa Barbara Land Trust. Sometimes you can get organizations like that to take title, but at the time, none of those organizations were interested in taking title to this land, and the only option that anyone could come up with was to form a nonprofit corporation that now owns these 5 parcels that I say that they're most of them are around Eland Place, at the end of Eland Place, the cul-de-sac that owns those parcels.
Thank you.
Okay. I have a question for Mr. Estrella, who's here, building official. I understand, I'm glad you're here today. Thank you very much. I understand from what Mr. Wiley says that if somebody were to come forward to propose to build a new home and to replace one of those that was lost during the fire, that they would still have to go through our process. So could you take a minute and describe to us and whomever is watching what that process would be for somebody who would want to rebuild in this area? What would they, it's not a prohibition against building, but they would still have to go through building and safety.
Correct. Well, prior to even getting into building and safety, there is a discretionary review process where they file an application with their planning department to make sure that they conform with certain setback requirements as prescribed by zoning. Once the design of the home is approved, the plans are then submitted into the Building and Safety Department, in which actually a variety of departments would review the plans. Our Fire Department, our Planning Department, our Transportation, Public Works Engineering. There's a variety of departments that have input into the construction of a new building. And so basically what we in Building Safety do is to ensure that the design of the home conforms to the minimum building code requirements as required by the state of California. And those are called the California Code of Regulations. And there's a variety of codes addressing structural, electrical, plumbing, mechanical systems, energy, even green building. So these new structures would be required to comply with all the codes to ensure that minimum life safety levels would be met for habitability.
Okay.
And so that's basically the process that is used. Mr. Wiley is correct that all new homes, all new structures are required to have a soils analysis. In this particular case, in the Canyajalo landslide area, it would be required to have a geotechnical engineer to evaluate the structural conditions as recommended by the Grover Hollingsworth report, of which those recommendations included in that report dated May, I believe it's 2009, would be applicable. And as Mr. Wiley indicated, there's a series of requirements and recommendations in that book that would have to be evaluated and considered also. So looking at the codes, looking at the recommendations in the Grover Hollingsworth report, assuming all those conditions could be met, quite possibly a permit could be issued for the construction of a new single-family dwelling.
Well, my question then that goes to, what if the soils were bad? And what if the expert opinion of somebody was brought in to review it based on Grover's Hollingsworth and all that said, bad place, don't build it here. But they went ahead and wanted to build it anyway. Does the city have any right at all to say no, you may not? Or is it really up to them to take that risk and move forward on their own?
That's a really good question. And, you know, one of the things that we are going to be relying on in this particular case is the applicant who has hired the geotechnical firm who's putting their license on the line basically to say that this is safe. Obviously, we want to do a check and balance, but unless there's something really significant and way out of alignment, we would probably allow that geotechnical engineering firm that will stamp the project off along with the structural engineer, architect. People are placing their license on the line to make sure that this home is going to be saved. So I think our design community, our geotechnical people, you know, they need to, you know, take a look at these properties closely and evaluating a potential design that would be considered safe.
Okay, so it would be on their professional, it would really be essentially the liability of its performance, if you will, would be on their advisors or their architect or whomever, the contractor, those people who would actually build in a condition like that. It would not be something that would come back to the city.
I believe that would be the case, although I think Mr. Wiley might have a comment on that.
You can understand my concern. If we let this go forward and then we're later found to be culpable because we created this ordinance, even in response to a court, it seems to me that there may be some liability that is owned by the city here, and that's why I'm asking these questions.
Mr. Chair, yeah, it's a good question, but fortunately, the Government Tort Claims Act is real clear about that, that there's an immunity, express statutory immunity for the government, for the city government in issuing a building permit. And I know a lot of people somehow think it doesn't work that way, that the city can be liable, for example, if a general contractor or subcontractor does something wrong, even doesn't follow the codes. But the Government Tort Claims Act is real clear that you can't sue the entity that issued the building permit. Just because they're required to issue these permits, it's a function of their property rights, if their permit application is consistent with the uniform codes. And that's pretty much when they get a licensed professional to sign off on it, that means they're consistent with the uniform codes.
I see. Okay, and I'll let you guys go in just a second. So I want to be sure I get this last little piece of it. So when the third owner, or the second or third owner of the house, after it's been constructed in there for a while, the house begins to fall apart, and they look back and see that we gave a permit to go ahead and build in that situation. You're saying tort claims, that act has literally protected us. It seems like the most important thing, though, is that the documents, the trail of documents shows that we have raised the red flag and said over and again, hey, you did the soils report, you did this and that. The city of Santa Barbara recognizes these. It just seems like there's got to be somewhere along the way that documentation demonstrates that the city did everything it possibly could to ensure that it was a safe.
Oh, and we would have all of that documentation in our street file and
All right,
in
thank you.
connection with the retained set of plans, yeah.
Okay, good. Good. Frank, go ahead, please. Mr. Hotchkiss.
Very quick question. I understand about the houses, but how about access to the houses? So if the roads become impassable, where do we stand? The fire department can no longer reach them. You see,
Right.
I'm sorry to just beat a dead horse here, but
No, it's a great question, but Councilmember Hotchkiss, and I've been in this business a long time, I don't know the answer. We actually are in litigation.
this is a first.
We're in litigation over this.
Right.
And there is an old case from the 1930s. It dealt with a flooding situation in the city of Los Angeles where someone lost access to their home because there was a flood, and the city wasn't responsible for the flood. None of the city structures failed or anything like that, but the court said to the city, you've got to decide whether you're going to fix the access or condemn the property. And it didn't answer the question, are we required to do one in particular? And we have that situation up in this area where some homes have difficult access. Some of it's private road access, and the law just doesn't provide clear answers to us.
Right.
They're in our jurisdiction, and normally we would maintain city streets, but at some point when the streets keep failing and it gets extremely expensive to keep fixing them, it's just a good question of whether we have to keep fixing that. I think we're going to get answers out of this Barajas litigation that we've got. In fact,
I just want that to be in our minds at some point, because that's the kind of thing you never foresee, and then suddenly it happens. Thank you.
Ross?
Thank you, Mr. Chair. Yeah, just to follow up on Mr. Hotchkiss's question, I had kind of the same one, but it had to do more with the utilities and sewers, since we don't allow septic, and there's a reasonable assumption you'd be able to get power and telephone and cable and so on and so forth. Is there a special assessment district, or do we have special assessment districts for problematic areas, or is that something that, for example, because you know that the ongoing sewer maintenance cost is bound to be higher in this area than it would be in the rest of the city. So do we have some provision for that, or is that unusual?
well, the city could look at creating an assessment district to do a special assessment to repair sewers, for example, because, I mean, assessments are a very common approach for installing sewers in the first place. So when you have an area that needs has some special needs, fixing those are what are called a special benefit, and a city can assess for a special benefit. It's difficult, you know. I know, frankly, the council on undergrounding districts, for example, has not really wanted to do assessment districts, even when it's been a minority protest, even when it's a small number of people protesting. But in theory, there's nothing about this area or this problem where the city couldn't pursue an assessment district and levy a special assessment, whether that's for kind of special fix to sewer lines or special fix to water lines.
Okay, well, we're getting to where we should probably have a motion, but I just want to go one step further with this. The way that this is worded, as used in this section, the term new construction shall not include the construction of a home on any legal parcel located within Slide Mass C where the parcel contained a home which was destroyed by fire or other casualty after November 12, 2008. So, and other casualty could be as the slide becomes really active and takes the house down. But by changing this definition, or amending it, it appears that the city will be in a position, and the city building official will be in a position perhaps of approving or giving a permit for construction of a home in a place that we may not be able to adequately serve or maintain the infrastructure for that home. No matter what happens to the home, we're required to fulfill on that, right? We're required to provide access, and we're required to provide the utility easement or utility places, and I don't know. But we're required to do that. If we give a permit, that's like part of the agreement, right? Mr. Wiley?
No, I think that's the same question Councilmember Hotchkiss just asked,
Okay.
and I don't
You just
know
don't
the
know.
answer.
Okay.
And I can't find it in reading the case law or in any statutes.
And there's no reason why we shouldn't put somewhere in here something that says that we may actually not be able to provide that at some point, or is that just begging the question?
I think we could certainly advise anyone who's pulling a building permit that they need to take some special provisions for their utility connections to make sure that those connections don't break, and make sure they understand that it's going to be a problem. It has been a problem. But like I say, there are homes in this area that have not had problems.
Doing okay.
486 Conejo.
Well, I share the trepidation of my colleagues here in that by us providing a permit for building, even if it were against our best judgment, because we've set up in the process of allowing a building permit, we're now going into a social a contract with the owner of that property that we're going to provide the basic municipal services to the property, and we don't have anything in here that gives us anything formal except for an advisory that would establish that we may not be able to do that. They can build if they want, but we may not be able to provide access nor the amenities that are the utilities that are required. So that's a really big concern. I look to you for any guidance. So you think it's your best advice that we can do this and just take it when it comes?
Yes, because
Okay.
I don't think it would be appropriate to put a general advisory of a potential future problem in an ordinance. That's really, I think the record's real clear with this land. If you're going to buy property in this area, for example, these things, if you were a real estate broker involved in an escrow in this area, you'd have to be crazy not to disclose this. It would be, talk about liability.
Yeah.
If you were a seller, you'd have to be crazy not to disclose all of this.
Right, and in fact, if we put that in the laws you're suggesting in the ordinance, that in itself could, I think, open us to liability on the part of these people who are saying you have devalued my land by doing this. So.
Mr. Stray has something to add, and maybe there's practices that the building department can offer, educational pieces or something.
Yes, Chair House, just a little bit of information that might help clarify just a little bit, not the whole question that you're asking, but prior to the issuance of a building permit, we do receive clearances from our utilities, from the city, and including the gas company and the Edison company. So we do not issue that permit until we have clearance. Now, the ability to service a property, that's a whole different question, whether or not we can or cannot. But that permit does not get issued until we have all the checks and balances in place that indicate that they can serve. Now, once the permit is issued, it goes back to a maintenance question as whether or not the city or other public utilities would maintain. And I don't know the answer to that question also. There's been a lot of rerouting of Edison lines and gas lines from our utility purveyors, and so they're doing their best, I know, to try to maintain utilities to these properties. But it is an area that we have not crossed just yet.
Okay. Well, I'm ready for a motion. As a person who was a planning commissioner 15 years ago, beginning to implement and watch out for this area with our ordinance, I just go into this with great trepidation, but I'm open to a motion right now.
Happy to make a motion, if I might, that we refer this to the full council with our recommendation that it be passed regarding construction prohibited in the vicinity of the Caneo landslide.
Do we have a motion? Do we have a second?
I'll second that.
Okay, and I'll say that perhaps if this will have a report going to council as part of the packet. It should reflect the concerns that were expressed here and your responses to it. I think the rest of the council want to hear that as well.
Good idea.
Okay, so without any other question, all those in favor say aye.
Aye.
Aye. Opposed? Nope. Okay, thank you. I don't think we have anything else. We're adjourned today. Thank you.